Okay.
Rose, did that make sense about the room?
I wasn't listening.
No, sorry, room 208.
Yeah.
So as
I
you
can't
go
remember
in,
it, but I'll find it.
yeah, if you can't find it, let me know. But as you go into the room, so there's 4 desks, the 2 on the left-hand side, the 1 by the window, that's where he's terminating sitting. So, but I hope to label some of the shelves or something, so there might be space in the cabinet for papers in there.
Because I'm going to collect something today.
Right, okay, yeah.
So I'll just probably dump it on his desk.
Yeah,
Like
either on the
post-it note or
desk,
something.
yeah, or in the cabinet, whichever's easiest. Yeah, that's great.
And he usually comes in, or like
He does come in because everything's electronic. He hasn't got a laptop. His car's been waiting for you to do.
all right.
Seem to have lost everyone behind you. But is that,
Abandoned ship, perhaps. I don't know.
do you mind starting with that?
I certainly don't mind. No, my lord, if you don't mind. My lords, my lady, I was going to turn to questions about commercial purpose and practicalities. We've addressed some of these along the way, but just to gather together some of the submissions I'd like to make. I'd like to develop 6 points, really, under this heading. The first point is that it needs to be recognised that the condition which is attached to this break clause is attached for the benefit of the landlord. It is not for the mutual benefit of landlord and tenant. And in my submission, that's a particularly important thing to bear in mind when considering what its purpose is and therefore what its meaning is. And as Mr. Justice Newey, as he then was, recognised in the Goldman Sachs case, what makes commercial sense from the point of view of the landlord may not make commercial sense from the point of view of the tenant. The fact is that in the market there are a whole spectrum of types of break clauses. At one end you have completely unconditional break clauses where perhaps all the tenant has to do is serve a notice. And right at the other end of the spectrum, you have clauses which require the tenant, as a condition of terminating the lease, to comply with all of their covenants. But there are many different variations in between those 2 ends of the spectrum. And it's notable that whilst this clause doesn't require full compliance with all of the tenant's covenants, it nevertheless requires, as a condition of the break, compliance with part of the tenant's covenants. Because what the landlord has done is taken out part of the yield up covenant, that part which requires the premises to be yielded up with vacant possession, and given that force not just as a covenant, which would sound in damages, but as a condition of the break clause. And it's true that the tenant is not required to comply with its repairing obligations or other obligations, but it's not right to say, as Mr. Mayle says, that this condition is not about compliance with covenants, because the landlord has chosen one part of the tenant's obligations as a condition of the break. And of course the reality is that the landlord and tenant will negotiate where along that spectrum of difficulty of compliance a particular break clause ought to fall. And I agree with Mr. Mayle that one would expect that to be reflected in the rent, so that a break clause which is unconditional is more valuable than a break clause which is difficult to comply with. And that will be reflected not only in the initial rent, but also on any rent review. So Mr. Moylan, particularly in his written submissions, sometimes in his oral submissions, has repeatedly used the concept of this being a trap for tenants. But in my submission, that's just a pejorative phrase. The question is, where along that spectrum of difficulty have this particular tenant and this particular landlord finally negotiated, given that it's a clause for the benefit of the landlord, which it has stipulated must be complied with if the tenant is to break its lease early and be relieved of its obligation to pay rent and comply with its covenants throughout the remainder of the term. I'd just like briefly in this context to refer to the Encyclopedia of Forms and Precedents that Mr. Mayle refers to, and if I could ask the court to turn that up at tab 10 of the authorities bundle. The first thing to note on the very first page is that it's the 2016 reissue. We're dealing with a 2002 lease, so of course nothing in this would have been assistance to the landlord and tenant and their advisors when drafting the lease originally. But if I take you to paragraph 670 on page 312, which Mr. Mayle read to you, see right at the bottom of the page, it suggested that the tenant should argue that there should be no condition precedent at all, on the basis that the extent to which the landlord suffers loss as a result of any breaches there may have been, he has a remedy against the tenant, and this can be pursued quite separately from the exercise of the option. So this is not a case where the tenant has succeeded in arguing that there should be no condition precedent at all. And as to the suggestion that somehow the language used in this break condition captures what is anticipated by the Code for Leasing Business Premises, which is set out at paragraph 287 at the bottom of page 138 and over onto the following page 139. Clearly, the recommendation here does not capture the concept of giving vacant possession of the premises, which is what the break condition requires. And in particular,
is that right?
Well,
159.3.2.
Because there are a number of things caught in the concept of vacant possession which are not captured by 159.3.2. For example, leaving your chattels behind to a sufficiently great extent that you are either using the premises for your own purposes or failing to give the landlord sufficient control so as to fail the second test in Cumberland and Ireland. There's nothing in there about leaving chattels behind. Equally, it's clear that a vacant possession requirement is breached or failed if there are trespassers in the property, and there's no reference to that here.
I, excuse me, rather took all those to be within the expression give up occupation. Because there are other things there you haven't given up occupation, including if there are possessions or...
My lord, I would submit that that would not be correct, and that it's actually rather different. What I would submit is that it's evident from the case law that conditions like ours that require the giving up of vacant possession cause all sorts of difficulties, and that's why we have a number of cases in the bundle where it's been shown that the tenant has failed to achieve that standard. The Code for Leasing Business Premises anticipates making it easier to avoid having those disputes by suggesting a form of words which does not involve the giving up of vacant possession. So it's actually in contrast to the requirement that we have in this case, and which has been litigated. And one sees that particularly from footnote 2, in particular disputes about the state of the premises or what has been left behind or removed should be settled later as on a normal lease expiry. And the cases that we have in the bundle about a vacant possession condition like Cumberland, like Expeditors, like Siemens Hearing and NYK Logistics and Goldman Sachs, and Riverside, I should say, are all about what has been left behind. So it's to avoid the disputes that we see in the case law that this recommendation is made. In fact, my understanding is that this code, and in particular this part, has been very little acted upon. I may be wrong, but one rarely sees a break condition which is following the recommendation which is set out there. So, and indeed, landlords continue in modern leases to stipulate for clauses like clause 10.1.4. The second point I'd like to make under this heading is that it's been recognised for a very, very long time that conditions attached to break clauses must be strictly complied with. And that's obviously common ground, and it's reflected in the judgment below. And the Siemens case is particularly useful in gathering together the authorities on that point. But there, Lord Justice Lewison noted that one of the earliest cases to reach the House of Lords on conditional options was in fact a break clause case. That's Gray and Fryer, which was decided in 1854. Essentially, for 150 years or more, tenants have known that if they sign up to a conditional break clause, they must strictly comply with it. And that is part of the context in which this lease was agreed in 2002. So we have
there's obviously a distinction between saying that you have to comply strictly with whatever it provides for, on the one hand, and saying on the other hand that it must be construed against the tenant on the other hand.
No, I'm not making that submission.
I mean, whatever it means, you have to do it.
Whatever it means, you have to do it. But my point is that, seen against the background that this is something for which the landlord requires as part of its negotiations, and the tenant has not negotiated away. The tenant has not negotiated away knowing that it will have to be strictly complied with. I think that's my point, my lord. The third point, which I've touched on earlier, is that the risk of non-compliance lies on the tenant, even in relation to matters beyond its control. And I gave the example earlier of a sublessee who remained in occupation despite the best efforts of the tenant to remove it. Equally, my learned friend says to the court, well, what about if vandals broke in and trashed the place just shortly before the break date? Well, what if trespassers break in and squat in the premises just before the break date? It's clearly established that if there are trespassers on the property, even if the tenant has done nothing at fault itself, that will fail to give vacant possession. And I've dealt with the insured risk issue too, that the lease contains a web of provisions designed to allocate the risks of certain things happening. And the parties have not chosen to negotiate a break condition which is qualified by reference to an insured risk occurring. So in my submission, the many what-if scenarios that Mr. Mayle puts forward are not an answer to our case and the one that the judge upheld. It's simply the case that this is what the tenant has agreed to, and the risk of failing to do so lies with it. The fourth point is that it makes perfect commercial sense that the landlord would wish to specify the property which is to be handed back with vacant possession as a condition of allowing the tenant to terminate its lease early. What I say is, why wouldn't a landlord want to ensure, as a minimum requirement, that it gets back the building it has demised and the landlord's fixtures which are its property? That's surely the minimum necessary to put these premises back into productive use when the tenant breaks its lease. And yes, it's true that part of that property might not be in repair, but one shouldn't confuse lack of repair with a complete redundancy. There may be all sorts of items which are not properly repaired or not properly decorated, but with a bit of work by the landlord can be put back into a state in which the premises can be let to the market. And the landlord will have the ability to claim damages against the tenant for the repairing works that it's carried out.
And it's tax you on that.
Yes.
One can quite understand why a landlord might want to make exercise of a break clause conditional on the property being in good order so they can relet. And that's achieved by a condition that exercise of a break clause requires the property to be in repair. And that hasn't been provided for. With the result that on your case, if the tenant lets the property go to rack and ruin, but nothing falls off, even though you can't relet, the break clause can be exercised. But if, on the other hand, the tenant takes away 3 carpet tiles, ceiling tiles, the break clause can't be exercised. Does that make commercial sense?
My lord, first of all, you're not contrasting like with like, as it were, because you're contrasting a complete state of absolute disrepair with 3 ceiling tiles missing is really de minimis, isn't it? So
I can make it 6. When does it stop being de minimis?
A more than de minimis quantity of tiles.
More than de minimis. Clearly, we can all see, and it's well known in the market, the difficulty for a tenant with a break condition that requires the premises to be put back in repair is that the smallest difference, the smallest item of disrepair prevents exercise of the break. And also, there can be an awful lot of argument about what constitutes disrepair and how the premises should be put back into repair. So one can see a tenant having a good argument with a landlord in the negotiations at the beginning of the lease, that just goes too far. Now, you're right, my lord, that an extreme case in which my argument would be applied would be one where there is absolutely terrible state of repair, but everything is still there. But that is not the most likely position. The most likely position is that there is some disrepair which can be dealt with, addressed by damages, which can be addressed relatively quickly. Whereas on the appellant's case, we have the potential for a complete demolition of the building, a complete removal of all of the M&E, for example.
But isn't that, I mean, then you're not comparing like with like. That's the wreck and ruin type case. You're taking the extreme for one type of situation, but not for the other.
Well, but that is, in my submission, the practical reality of what happens day to day in the market is that landlords are probably prepared to agree. No tenant is likely in the modern market to agree readily to a break condition which is conditional upon the carrying out of repairs. Full compliance with the repairing covenant, because it is so obvious that that is likely not to be complied with. And therefore, a landlord is unlikely to ask for it in the first place and unlikely to get it even if they ask for it. But in my submission, it is different when you're talking about what is the property that the landlord wants to have back. And having made that part of the yield up covenant, having said you must yield up the premises to me as part of the yield up covenant, in my submission, it does provide a minimum requirement, an understandable minimum requirement that the landlord will want to do that and say, and you can't exercise your break condition. You can't exercise your break unless you've done that. And I know we're talking about generalities and it's a question of construction, but this building was left in an absolutely dire state, and the court does have the photographs. I won't take you to them, but if you're at all interested, they start at the core bundle at page 174, and you can see the absolute state that this building was left in. And my fifth point is that, conversely, it makes no sense that the landlord would give the tenant the choice over what it hands back. And that is the consequence of the argument that the premises mean whatever happens to be there at the time. What that means is that the landlord, for its benefit, has stipulated something as a condition over which the tenant has absolute control, because it can decide whether it demolishes the building, whether it strips out all of the fixtures, or whether it takes away some of the ceiling tiles. And that's why, in my submission, it's so important to recognise that this is a stipulation imposed by the landlord for its benefit. So why would it do that and say, you can give me back anything that you choose to?
How does that fit with 320?
It is, in my submission, consistent with 320. In that, Your Lordship, I hope, has my submission that the requirement in 320 to yield up the premises to the landlord at the end of the term with vacant possession, if we take it to that point.
I'm actually talking about the rest of it.
The rest of 320.
In other words, in a state of repair, condition, decoration, which is consistent with the proper performance of the tenant's covenants in the lease.
Yes.
You're saying that if clause 10 is read as the appellants propose, then the landlord has no rights over, you put it, what is handed back.
Yes.
But the landlord does, because the landlord, the tenant, has to give the property back in the state of repair, condition and decoration, which is consistent with the proper performance of the covenants.
Yes. So I think what Your Lordship is putting it to me is the landlord has something, it has its damages claim. But I think my point is a slightly different one, which is that the landlord has imposed a condition, and that condition is to give vacant possession of the premises. If my learned friend is right, that the premises means whatever happens to be there, then what is the point of the condition? What is the point of the reference to the premises in the condition?
Well, you were submitting that it made no sense for the landlord to have no choice over what's handed back, as though the landlord was, as I sensed your submission, unprotected, didn't have rights. And so the landlord does have rights, because the land has a right to, as you say, sue for breach of the repairing covenant.
My submission is not that the landlord has no rights, but that it makes no sense for the landlord to have required the giving back of the premises if the premises means, as the appellant says, whatever is there at the time.
I mean, it's still a very valuable condition, getting vacant possession of whatever is there.
Undoubtedly, it has its benefits. I'm not suggesting it has no benefit, and I'm sorry if it sounded like I did, but it is, as I say, it is the necessary consequence of finding in Mr. Mayall's favour that that's what the premises mean. That
Sorry, go on.
a clause which is in the landlord's interest, which it is entitled to waive at its own discretion, effectively gives the choice of what property is returned to the tenant.
Well, one thing that I'm not sure I've thought this through, but I mean, maybe one reason why one doesn't have arguments about the meaning of premises is everybody thinks this is about repairing. When you find some ceiling tiles are missing, you don't say, oh, I'm not getting back the premises. You say, there's been a failure to repair. And then you don't need to worry about the precise meaning of premises.
Well, possibly the particular factual scenario which we have here hasn't been looked at before. But in my submission, that doesn't make our position wrong. It merely means that we need to look at it, look at it for the first time. And we're not, you know, my lord puts to me ceiling tiles repeatedly. I know ceiling tiles are one of the things that were missing, but so was an awful lot else.
Yes.
All the radiators and.
I think Mr. Mayle sort of holds up his hands.
Yes, he holds up his client's hands indeed.
Yes.
And perhaps to respond to Justice Moylan's point that the landlord has its remedies, which is a rather different point. The landlord has its remedies for vacant possession too, because it has the yield up covenant in 320, which applies as at the break date. And yet, the landlord has stipulated vacant possession as a condition of the break. So clearly the landlord, in negotiating this lease, has decided it is not enough to have a damages claim in some respects. My sixth point under this heading, and last point, is that the practical difficulties of compliance put forward by Mr. Mayle are overblown. And that is primarily because where you have a break condition which requires vacant possession, it is already not straightforward to comply with. It's already quite a long way down that spectrum towards compliance with all covenants. And in practice, the decision that the judge has made and that we seek to uphold doesn't add anything of significance. So, for example, Mr. Mayle says, but look, Mr. Burns, the surveyor for my client, had to carry out a historical inquiry to work out what the original building comprised of and what had been added, what was a landlord's fixture, what was part of the base build. But you also need to do that when you're working out whether or not vacant possession has been given. So it's relevant in the vacant possession context to know whether you're dealing with a fixture or a chattel. And that involves a very detailed inquiry with potential for considerable uncertainty. Because the test for whether an item is a fixture as opposed to a chattel depends not just on the degree to which it is annexed to the land, but also the object and the purpose of that annexation. And one only has to formulate that test in my submission to see that there's plenty of scope for litigation about it. By way of practical example, at the time of the Riverside case, the textbooks said that partitioning was probably a fixture. But His Honour Judge Safman in that case held that the partitioning which was there in situ was actually a chattel and therefore was required to be removed in order to give vacant possession. So that involves quite a difficult and detailed inquiry with the risk of getting things wrong. Equally, it's relevant to know what is a tenant's fixture, which may be removed and perhaps under some leases must be removed, and what is a landlord's fixture, which is part of the premises to be left behind. and that the test for whether or not something is a tenant's fixture is even more complicated. For your Lordship's note, Lordship and Ladyship's note, it's mentioned in the Peel Land case at page 305. It involves the question whether or not the item has been affixed by the tenant. So that's going to involve the sort of historical inquiry that Mr. Burns had to carry out. Secondly, whether it was affixed for the purposes of the tenant's trade or for mere ornament. So that's a purposes test, which is going to require judgment. And thirdly, whether or not it's physically capable of removal without causing substantial damage to the land and without losing its essential utility as a result of the removal. So you're going to need a building surveyor's advice as to what will happen when this item is removed. So all of those matters, and we see them being discussed in the case law in the context of vacant possession, all of those matters need to be dealt with as a consequence of complying with this break clause, whether or not the judge is right and we're right. And so we say the judge being right adds very little. And the practical reality is that the original tenant can retain plans, take photographs, assignees can stipulate for those documents to be passed to them as part of the assignment. And that's the reality of litigation about break conditions. And we say that the issues raised by the decision below are no worse than any others that we routinely see in the case law in relation to these types of break conditions. And that's the lived reality of landlords and tenants in this market. They know they have to do this because they know when the time comes they have to comply with their break conditions. Excuse me a moment. Sorry, excuse me for turning my back. I just wanted to check that I'd covered off everything I ought to. Unless there's anything else I can help you on that ground of appeal, those were my submissions.
No, thank you very much indeed.
I'm just going to whistle very quickly through the other part of the appeal to deal with this very briefly, the point about procedural irregularity, which is raised. You've seen set out in my skeleton argument the chronology of how matters were dealt with.
Does it matter at all? I mean, you're not actually suggesting that the way in which Mr. Mayle interprets the judge as deciding the case is right. You're not relying on Cumberland at all.
No, I'm not relying on Cumberland. It is only, my position is that it is only that one sentence which relates to Cumberland, which is odd and out of place in this judgment. The rest all makes perfect sense.
I mean, it may be more than one sentence, but it really doesn't seem on either of your cases to matter in the least, because we're dealing with the substance rather than...
Yes, indeed. What I would just like to flag, so that your lordships have it when you consider this particular aspect, is that in part the judge is reflecting submissions I made to him, and if I can just show you those in my skeleton argument for the original trial in the supplemental bundle, page 50. Sorry, that's page 50. Paragraph 26, I addressed the commercial purpose of a condition like 10.1.4, and at the end of that paragraph, I made submissions about the reasons for imposing a requirement to give vacant possession. And I said at the end, to hold that a tenant can render the property unlettable and unusable by removing substantial parts of it were quite contrary to that purpose. Mr. Mayle says he can't understand where the judge got the idea of, I think he uses the phrase dysfunctional and unusable. But in my submission, he's simply reflecting the submissions made to him in that paragraph about the commercial purpose. The other point I would just like to flag to your lordships, if we go to the judgment, it's page 85 of the core bundle, paragraph 67. And it relates to the sentence about 4 lines down, it did not give vacant possession. And I just wanted your Lordships to be aware that I had specifically raised, I'd suggested that for clarity the judge should add of the premises after that, so that it did not give vacant possession of the premises. And Mr. Mayall's response was that that was not needed because it was clear enough. So he must have been accepting that what the judge was saying was it did not give vacant possession of the premises.
I mean, it is not your case that the tenant did not give vacant possession.
Well, it did not give vacant possession in the sense that it did not leave things behind that we say breach the requirement to give vacant possession. But it failed to comply with a condition in 10.1.4 which required it to give vacant possession of the premises.
Yeah.
It is a single condition, or there are multiple ways in which that might be, there might be a failure to comply with it. So in my submission, it is only that one sentence which relates to the second test identified in Cumberland, which I can't support as being relevant to the analysis which the judge was asked to carry out, and which he did carry out. But we would say that's superfluous, since he did make the findings that were necessary for the analysis that he was asked to carry out.
Yes.
In the end, the findings don't really matter at all because you don't disagree on the facts. It's just
No, exactly. My lords, my lady, is there anything else I can assist you with?
I don't think so. Thank you very much indeed. Yes, Mr. Mayor.
Thank you, lady. Simply a few short points. If the court has close to hand page 293 with clause 10.1.4 open, excuse me. Well, I say that is simply directed to vacant possession. I asked the court, I'm so sorry, not to make the clause do too much work, as I think I put it in opening, and to extend it to an exercise where one has to consider the condition of the property, these vexed questions about tiles in corners of rooms or tiles in skips, or the effect of flooding and fire. And I, as your lordships know and my lady knows, I rely on the language used there. I say it doesn't go far enough, but I also rely upon the contrast with the yield up clause, which is very much clearer. And again, you may have that close-handed for the note, the court's note. It's page 285, clause 320, where it spells out when the parties have to look at the condition of the property. And I also rely upon the absence in the break clause of any requirement that the tenant should comply with conditions. And I do still maintain that this is an attempt to reintroduce by the back door that sort of requirement. It may also help, your lordships and my lady, when you're writing your judgments, just to step back and consider the consequences of the two rival cases which have been brought out in argument by questions from the court. Our approach is simple. The tenant gets to the break clause date, it leaves, it doesn't become engaged in difficult questions about the condition of tiles, the condition of roofs, the condition of any fire damage. And that, in our submission, is consistent with the purpose of the break clause. The parties need to know at or about the break date that the landlord can take the property back and re-let it, and the tenant is free from its obligations. It became apparent during the course of argument in my submission, with questions put to Miss Wicks, that her approach raises all sorts of difficulties which may have to be gone into. Have doors been changed? Have walls been knocked down? That sort of thing. And there is a scheme in my submission to the lease. The scheme being that if the parties, if the tenant breaks under the break clause, then dilapidations, condition of the property, that sort of thing, reinstatement are all dealt with later on. And that, of course, is consistent with what was in the code. Now, the point is made, well, the code is in a copy of the encyclopedia, which is in late 2000s and teens. I simply relied upon it as indicating the sort of thing sensible parties would be likely to agree to. And your lordships needn't turn it up. I think it was footnote 2 to paragraph 159.32, where it says disputes about the state of the premises, what has been left behind or removed, should be settled later as on a normal lease expiry. In my submission, that is what the parties were trying to do here when they set up this scheme, and they used the clause 10.14 in its very limited form. I'm trying here just to follow Malone Friend's submissions. Malone Friend referred to the legal general case in my submission. That really doesn't assist. I think it's apparent from the way in which the arguments have been put to your lordships and my lady that there is no case at the moment which deals with this point. And I think the same point arises out of an exchange between my Lord Justice Newey and Miss Wicks when the question was put, well, do any of these cases concern a break clause with this particular condition? They don't. This is a first which your lordships and my lady will have to contend with. I do still rely upon the examples I gave in opening, in particular the example of fire, which is one of the insured risks. If there's damage by fire, then the court knows that that responsibility for repairing, dealing with that, is carved out of the tenant's repairing covenant, and it forces the landlord to reinstate. Malone Friend very candidly, as I understood her submissions, accepted that in that situation the tenant could not break. In my submission, that simply cannot be right. Two commercial parties in this situation could not have intended that should be the consequence. And if the court adopts my approach, then that unfortunate result would be avoided. As I understood Malone Friend's submissions, she accepted also that if my clients had done everything by way of reinstatement, but, and sorry, this is the ceiling tiles again, but there was an area of ceiling tiles which had not been replaced, perhaps because the builder ran out of time, it was midnight and the break date was arriving, then on her approach, that would defeat the exercise of the break clause. Again, I say that cannot be what two commercial parties intended. And as I understood the submissions, they went as far as this, that if one looked back at, the original ceiling tiles, and they were taken away, then we would fail. But the implication seemed to be that if those ceiling tiles were still in a skip within the demised premises, say in the yard of the demised premises, then, as I understand Malone Friend's case, we'd be all right. But of course, if the skip was outside on the highway, we wouldn't be. If a case produces that sort of result, where my Lord Justice Moylan was asking, well, is the poor old tenant supposed to give vacant possession of something which is actually in the corporation refuse dump? Again, that's a big, big question mark over the landlord's approach in this case. There was one point where I think Malone Friend was suggesting, well, if the tenant didn't put in the right sort of ceiling tiles again, that would be fine because there are ceiling tiles in. That's not the case because Malone Friend's case, which I understand she's not resiled from, and for the court's note, this is paragraph 4, brackets 5 of her skeleton. 18 of her skeleton and 21 of her skeleton. The qualification which she imposes is that where there have been changes because one or both parties have complied with their obligations under the lease, then there's not a problem. That, as I said in opening, is going to raise all sorts of problems for tenants if the court adopts this approach, because the landlord's going to go around the premises on the break date, look around and say, well, you've not complied with your obligations. This is not the original premises. It's not a change in compliance with the terms of the covenant. This is not the premises. There's another reason in my submission why the court should reject her approach. I think at one stage, Len may have said, well, actually, it's going to be an alteration if it's not a repair. But the court will need to consider alterations covenant, which is at page 272. And I took the court through this in opening. At 272 and 3.4.1, there's an absolute prohibition on any structural external alteration. But then any non-structural alteration requires consent with a capital C. That is defined on page 2x62 as previous consent in writing. But then also under 3.4.4, where the landlord's given consent, the tenant has to carry out the works in accordance with plans and specifications. So if the poor old tenant puts in these substandard ceiling tiles, they can't be an alteration, which is consistent with Moylan Friends case, because they are not alterations in compliance with, and I stress those words because those are mixed with Ms. Wick's words in her argument, in compliance with the obligations. And so, harking back to a point I made a few minutes ago, our approach is simple and straightforward. It avoids the sort of unfortunate disputes which can arise between landlords and tenants. In contrast, the respondent's approach would give rise to those. And I think all those, I'm still just dealing with points arising out of this morning. So far as Moylan Friends submissions on always speaking are concerned, the court knows that we say always speaking applies both to additions to the premises and subtractions. There's no logic to an approach which simply confines them to additions. And as my Lord Justice Moylan pointed out, the definition of the premises themselves has a sort of always speaking or from time to time approach. If one goes back to page 265, the Lord Justice Moylan pointed out to Miss Wicks that in line 4, it talked about all fixtures and fittings at the premises. In my submission, that is an indication that in those very terms there, the parties were looking or taking an always speaking approach. Again, in the course of argument, I think Miss Wicks accepted that her approach involved reading words into either the definition of the premises or into clause 10.1.4. I accept that my always speaking approach involves reading words in. I read in words from time to time. In my submission, the words I read in are the more likely to be intended by the parties and are more consistent with indications in the lease, such as the one we've just seen, the fact that there are obligations relating to the premises where the tenant has to allow the landlord to inspect the premises. But so far as this afternoon's submissions are concerned, I'm Moylan Friends 6 points. I think a point arose in discussions between the court and Ms. Wicks about the value of clause 10.1.4. In my submission, our approach does not rob that provision of value. Getting vacant possession is beneficial to a landlord. He gets the property back free of people, free of chattels and free of legal interests. And he can then go about marketing it. I think there was then a discussion between the court and Miss Wicks about the code and the reference to the word occupation. I would read the word occupation slightly different. I would say that if there are chattels or people, such as employees on the premises, then the tenant will still be in occupation. I think the court was then invited to look at the photographs of the premises, and again, if the court looks down, I have my hands up. This is, on the facts, a very extreme case. It may be that's what influenced the judge, and it may be in due course my clients are going to have face a very large bill for dilapidations or reinstatement, but that should not affect the outcome of the exercise of our break clause. It is then said that my approach gives the tenant the choice of what to hand back. This is, in my submission, a little unusual submission to make. The tenant in this case was a reputable media company. The assignee was a reputable media company running many, many radio stations. The idea that the tenant, or a business tenant, is going to in some way manipulate a clause like 10.1.4 to its advantage, in my submission, a little far-fetched. It's then said, both in skeleton order submissions, that I've overblown the practical difficulties. In due course, the court may want to look at or skim read Mr. Burns's report, which he had to carry out in order to establish the original condition of the property. He had to look at drawings, which we didn't. He had to do a lot of research. He came up with a lengthy report. Again, I raised the question, did the parties really intend that? And there's quite a pithy point on which to end from a judgment, or the judgment of Mr. Justice Newey in the Goldman Sachs case. The court has that at tab 6. This is not sidelined, but I found it over lunch. At page 417, paragraph 56, Mr. Justice Newey is dealing with, I think, arguments made by Mr. Sietler. And 5 or 6 lines from the end, Mr. Justice Newey says this: as Mr. Sietler said, in the course of a short but effective reply, the one thing which does make commercial sense for both landlord and tenant is to know without much difficulty whether break clause has been validly exercised or not, because the tenant will want to know whether it really has to leave, has no further liability of rent. Landlord will want to know whether it will get the premises back and have to re-let them. We say our case gives effect to what Mr. Justice Newey accepted, whereas it's apparent from the interesting examples that came out of Miss Wick's submissions that the landlord's case does not. That's my reply on the main point. Procedural irregularity in my submission, it doesn't make any difference, and it looks as though the amendments either never got to the judge or he just wasn't interested in them. I think the more likely one is they never got to the judge. Thank you very much, my lady. Thank you.
Thank you. Thank you. I haven't got any questions. No. Well, thank you, Mr. Mail, Miss Wicks, for your respective submissions. We will be, as you will appreciate, reserving our judgment. It will be distributed in the normal way in draft for typographical and the like corrections. I know you know that, but I'm just saying it. Probably will still be handed down remotely, and we would hope that once you receive it, you will be able to agree draft order, but if not, we'll deal with any outstanding matters on short written submissions. So thank you again. Thank you very much.